Seeking justice for crimes of the past, Croatia and Serbia accuse each other of genocide. But can they achieve reconciliation through the courts? This is Inside Story. Hello and welcome to the show. I'm Sami Zeidan. Well, it was one of the many conflicts to shake the Balkans during the breakup of former Yugoslavia. Around 20,000 people died in the fighting between Croatia and Serbia in the 1991-95 war. Both sides accuse and are now suing each other for genocide. It's the most serious of international crimes, but one of the hardest to prove. Ivan Pavkovic at The Hague helps get the discussion going.
Croatia has filed more than 2,700 pages of documents. Croatian legal advisors are saying that there is more than enough material and arguments for judges to conclude that there was a genocide committed in Croatia against Croats, especially during the siege of the city of Vukovar in 1991. They are saying that they are expecting from this court to tell the truth to Croatia, to Serbia and to the world. On the other hand, Serbian attorneys claims that there was a genocide committed against the local Serbs in Croatia during the military Operation Storm in 1995. In that operation, Croatia took control over the parts of the country which was controlled by then by local Serbian rebels. And what's interesting that testimonies here were under embargo till today, and it seems that the most interesting witness was Sonja Biserko. She is president of the Serbian Helsinki Committee. She explicitly said here that Serbia is responsible for fall apart of ex-Yugoslavia.
Well, I want to set this in context in a moment, but first let us introduce our guests for this episode of Inside Story. Joining us from the Serbian capital, Belgrade, is Sonja Biserko, president of the Helsinki Committee for Human Rights in Serbia, who Ivan mentioned in his report. In our London studios, we have Geoffery Nice, who was chief prosecutor in the war crimes trial of former Yugoslav president Slobodan Milosevic. And from Nottingham in the UK, Marko Milanovic, a lecturer at the University of Nottingham School of Law and an associate at the Belgrade Centre for Human Rights. Now, as I said, just to give a little background before we get going, let's talk about the cases being heard at the International Court of Justice. Well, they relate to the conflict in the former Yugoslavia in the 1990s. Back then, it was a federation of 6 republics that brought together Serbs, Croats, Bosnian Muslims, Albanians, Slovenes and others. Yugoslavia was ruled by President Tito up until his death in 1980. Well, once he was gone, ethnic and nationalist differences began to flare up. Republics began breaking away, and the Serb-dominated Yugoslav army tried to stop them. Well, that led to conflict, first in Slovenia, then Croatia, before spreading to Bosnia. Some 100,000 people died before international intervention ended the war. NATO bombed Bosnian Serbs in 1995, and Bosnia, Serbia and Croatia all signed the Dayton Peace Accord. Let's take the discussion to our guests then. And Geoffery, this round of litigation, as we know, started with Croatia wanting the International Court of Justice to say Serbia is guilty of genocide. With what we know about how the proceedings have gone so far, how likely do you think that is?
Well, you can't really expect me to offer a public opinion on a matter that's before a court and when I haven't heard all the evidence, and I won't do so. What's interesting about this case is that it's come some time after the conflict was ended, and indeed some time after the criminal cases before the International Criminal Tribunal for the former Yugoslavia that touch on this issue have probably all now been dealt with. And what's interesting is that the evidence looks and feels rather different from the way perhaps we had forecast that it would look and feel, and also perhaps rather different from the way it appeared in the criminal trials against individuals. There is something of an advantage in a short distance or a mid-sized distance between the events and their being reviewed in a court such as the International Court of Justice. And I would have thought that the laying out of the evidence by Croatia against Serbia looked rather stronger than people might at one stage have expected. That's not to express any view about the final conclusion, which is something that will be decided upon by the judges both on issues of law and fact. But the way it was presented, I think, was something of a surprise to some of the onlookers.
Right, a bit of a surprise. Let's bring Marko into the discussion. I don't mean to actually ask you to give an opinion on a case that's ongoing right now, but what I mean is looking at, if we would, the precedent. Since the International Court of Justice was established in 1945, it has only ruled once that genocide was committed. That was in relation to Srebrenica. That's when Bosnian Serb forces killed thousands of Bosnian Muslim civilians in 1995. While the court acknowledged Bosnian Serb forces committed a genocide, the ICJ stopped short of declaring Serbia responsible. And if you could give us a perspective of how difficult it is to actually pin responsibility for a genocide on a state. Is that unlikely given past rulings?
Well, actually, I'm happy to give you an opinion on what will happen in this case. I think it is extremely unlikely that the ICJ will find either Serbia or Croatia responsible for genocide. And that's because in order to actually succeed, both of these states have to prove two things. So they have to show that A, genocide was committed, and B, they have to show that it was committed by people who are agents or organs of the other state. And both of these topics are incredibly complex. So as you said, in the Bosnian case, the court found that genocide was committed in Bosnia, but only in July 1995 in the massacre of 8,000 Bosnian Muslim men and boys in Srebrenica. But all of the other stuff that happened in Bosnia, which was incredibly bad, the court found did not qualify as genocide. And then even for the actual genocide in Srebrenica, the court found that it was not perpetrated by people whose actions were attributable to Serbia. So it said essentially it was done by the Bosnian Serbs, but Serbia did not control what they were doing. And on those grounds, we can predict with a high degree of confidence that the court will say there has been no genocide in Croatia on either party because simply the intensity of the crimes was not there, and genocide is different from other crimes in international law by requiring a specific intent to destroy a protected group, and that you did not have on either side of the conflict. So that will be incredibly difficult.
All right, Marko, they're more confident to look at where this is going perhaps than Geoffrey. If I could bring Sonja into the discussion here. Some might ask, how useful are these court cases given how tricky and difficult it is to try and pin a crime as big as genocide on a state?
Well, this is a good question because since these two states didn't withdraw the lawsuits against each other, though there was a lot of pressure on both, this ICJ record will be really historical and maybe one of good starting points for two countries to start dialogue on what has happened in the 90s. And this is the real value of this trial. And since it is really the highest legal institution of the UN, both sides will have to respect whatever judgment is going to be brought. So I see really this as an opportunity for the two sides to come up with their own arguments. They had to be very disciplined in the way they put them forward in front of the court. And I see really some value to this whole effort since it already took the place. It also very much depends how both governments will be using these records and how they will treat that in their public, through media, through academia, through, by starting a real dialogue and normalization process between the two countries, which are both of them very important for the regional dynamics and regional stabilization.
But Sonja, we've had a ruling, for example, in 2007 in the case of Srebrenica. Has that really produced that dialogue, that understanding and a moving forward of relations between Bosnia and Serbia?
But the major problem here in Serbia, since I come from Serbia, is that Serbia denies any involvement in the war in Croatia and Bosnia. And this is something which is systematically being put forward to our public. Serbia was not at war, therefore there is no responsibility. We are the victims of those who seceded, and we are the ones who really suffer. And this is the official narrative which apparently blocks developments in the region, both with Croatia, Bosnia and Kosovo. And I think maybe this judgment, considering that now all these states are on the way, are in the process of approximation to the EU, maybe this dialogue should be started. Maybe it's too early also, because we need new generations, new, more mature leads who will be able to pick up this as something which is really key to normalization of the situation in the region, and it is popping up almost on a daily basis. The history of the 90s, which is being denied, especially from here from Serbia. And maybe this trial could be a contribution to that, because Serbia will not be able to deny continuously its responsibility in the wars in the 90s.
All right, bit of optimism perhaps then there from Sonja. Let's take the discussion back to Marko. Do you see any reason to think that whatever the ruling might be this time, that it would lead to more of a reconciliation between Croatia and Serbia than we've seen between Bosnia and Serbia following the 2007 ruling on Srebrenica?
Well, frankly, I have to say I doubt it. The Bosnian ruling did produce something, in the sense that after the Bosnian judgment was handed down, there was some kind of dialogue within Serbia as to what Serbia's responsibility was. The National Assembly did adopt a declaration, though, on the Srebrenica genocide, though it actually avoided the word genocide. I don't think this will happen here, because, again, the most likely outcome is that the court will say there's been no genocide on either side. We don't have jurisdiction to decide on the responsibility for any of the other crimes, be they war crimes or crimes against humanity. Therefore, the judgment will not say anything. And so if the only thing the court says there was no genocide, I mean, there's nothing really to reconcile. And I'm afraid that nationalism is so strong, both in Serbia and Croatia, that people will just continue believing what they continue to, what they believe, what they want to believe. These official narratives are so strong that even if the court came out with a very strong judgment, and I very much doubt it will, I don't think that will change anything.
All right, let's bring Geoffery back into the discussion there. We've heard from Croatian and Serbian leaders. They've both hinted at a desire perhaps to withdraw their cases. Why, and why haven't they?
Well, I can't explain why they haven't withdrawn them, although I think the rumours were at one stage comparatively strong. I have no doubt that, having pitched in as they have done, there will be no question, at least I'd be very surprised if there's any question of withdrawal now. Can I just make a couple of other points arising from the recent contributions? First of all, trials, whether at the ICJ or at the criminal courts, are unlikely to achieve reconciliation. It always seemed to me odd that it was thought they would. Trials are not designed to achieve reconciliation. They have other objectives: punishment of individuals, reparations. Second, although I decline to express any view about the outcome of this particular case, or these two particular cases, one each against the other, I think that what we've seen at this trial, and I sat in on some but not all of the days, is that the business of presenting a genocide case is actually much simpler than might have appeared when the Bosnia case started and had the particular outcome that it did. Now, whether that will encourage, as some, including I, have suggested might be sensible, Bosnia to attempt revision of the case, as it can do in certain circumstances under the rules, I don't know. And whether it will encourage any of the other small states also to seek the record, to put a record at that court, I don't know. But I think it's quite clear, and I disagree with Mr. Milanovic on this, it's quite clear that it can be easy, if the evidence is there, to prove the elements of genocide. And the third thing I'd like to say, arising from the contributions of both your other two guests, is that these trials, unhappy though they may be, and little though they may do to bring reconciliation, may be very important in leaving a record. And once you start the process of using court hearings to set a record, then there are risks for any countries that could use the court in that way if they don't do so. It's one of the real issues and one of the real problems, some would say, arising from the overall business of reviewing the Yugoslav conflict through the prism of courts of one kind or another. But because the court process can be used, and some would say has been used, by some of the states of the former Yugoslavia to rewrite or to write history, it becomes pretty important for the other states to consider doing the same things themselves.
Geoffrey, if I can jump in there, I'm interested when you said there that you think in these two cases things are perhaps a little clearer than in the Bosnian case, the case of Srebrenica and the ruling in 2007, if I've understood you correctly. Could you elaborate? What do you mean that things are a little clearer in this proceeding?
Well, I think in these proceedings it became very clear how easy it is to line up two things, to line up your evidence and present it. It also became clear that if the legal test that in fact both Croatia and Serbia seek to apply to prove their cases on genocide is found to be the appropriate test by the court, and as to that we have no idea what the outcome will be, but if the test that both sides have said should be adopted is adopted, then it might be rather easier than people had thought to prove genocide, because in order to prove genocide you may only have to prove the relevant genocidal intent in respect of a small part of an identified community. And if that's the case, then of course in the setting of records others may want to use the courts for the same purpose as some would say they've been being used by Croatia and by Serbia. All
right, so if we follow that thought, let's take it back to Marko. If I've understood what Geoffrey's saying here correctly, perhaps we could be setting a precedent for an easier sort of the bar of evidence level to consider or to pass a judgment on a genocide case could be one of the outcomes of this case. Do you agree with that?
I mean, sure, if the court went down that path, but I very much doubt that it will do so. Because how could it say, for example, that the siege of Vukovar was genocide, but that the siege of Sarajevo in Bosnia was not? And it already said that Sarajevo was not genocide. How could it say that whatever happened in Croatia is genocide, but that, for example, the Prijedor camps in Bosnia run by the Bosnian Serbs were not genocide? So we are not starting here from a blank slate. We already have the Bosnian case. And the Bosnian case dealt with atrocities which were of a magnitude greater than what we have in Croatia. And if those were not genocide, other than Srebrenica, then there is no way for the court itself to say, okay, the stuff that just happened in Croatia was genocide. I mean, it would be completely self-contradictory.
All right,
and
very briefly, let me bring in
that the court will go that way.
Your response to that, Geoffrey. Is it really possible for the court to lower the threshold of evidence without contradicting previous rulings?
Yes. These courts of many judges are well known for holding varied views within the bench of judges, and it's always possible for courts to change their views on the law or indeed on the facts over time. In reverse order, they can change their view on the facts when evidence previously not available to the court becomes available, as for example in the case of the Bosnian Serbia case, where evidence that might have been available to Bosnia was withheld from the court for various reasons that some regard as unsatisfactory. So far as the law is concerned, you have only to look at the decisions of a different court, the ICTY, which is persuasive in authority, but to see how over time really important approaches to the law have changed, for example on aiding and abetting within the last couple of years, so as to change the threshold for that component part of a crime.
Right.
The law emerging from these courts, which are in a sense dealing with new topics, and some of them are new courts, can change.
All right,
and indeed their view of the facts can change.
Let me bring Sonja into the discussion. How enforceable are the rulings? The ICJ doesn't have the power to enforce its own rulings, so how enforceable are they at the end of the day, Sonja?
Well, I think for the public in the region, it's extremely important to follow this discussion as it is already presented in our media, maybe in a limited scope. But I think it may serve to understand the context and why Yugoslavia has collapsed in such a brutal way. And this is the main question for me as a human rights activist, as someone who has been involved in the last 25 years in researching and following what was happening in the region. And I think in terms of reconciliation, it truly has to take decades, probably, like in many other cases after the Second World War. But each of these cases in front of the court were really a learning process, not only for us as a public in the region, but also for the lawyers who were defending or putting the case in front of the court. So there are many lessons learned in these processes for the wider public, not only region. So I think it's always worthwhile to look at it, and I hope that we will have future-wise some more mature elites who would be able to take this maybe as a starting point or the framework, because there is much more to say about the world, about the wars in the 90s, especially the decade before it started, because this decade, I think, is crucial to understand what was going to unleash in the 90s.
All right, Marko, we already have the International Criminal Tribunal for the former Yugoslavia, or the ICTY. That court is pursuing justice against specific individuals. What does a ruling from the International Court of Justice give that the ICTY rulings don't give? Is it just about establishing the official, if you like, historical record of what happened?
Well, no. I mean, as Geoffrey said, courts are not there to write history, and to the extent they need to establish a factual record in order to apply the law to the facts. Well, what the ICJ brings is a different level of responsibility. Rather than the responsibility of individuals, it determines the responsibility of states. And it can do that very effectively if the facts so allow, and if the law so allows. For example, the court found
hang on, Marko, you just made the point that
Mhm.
it's very unlikely that the court would actually be able to do that, to pin responsibility on states. So my question again, what actually
in this case, it
does
would be
it
very
give?
unlikely. Well, in other cases, the situation would not be so difficult. Because remember, the problem here is that the court, in this case, only has jurisdiction for genocide. In other cases, it can have a much broader jurisdiction. So, for example, in a case brought against Uganda by the Congo, it could look at all the possible violations of international law committed by Uganda, and it found Uganda responsible without much difficulty. And now the two states have been negotiating for many years now on how big of a compensation Congo will be due. The problem with this case is that it's jurisdictionally very narrow to genocide only, and that genocide is difficult to prove, especially to distinguish it from crimes against humanity and ethnic cleansing. In some cases, it is easy to determine genocide, or relatively easy, like in Rwanda. In cases like Bosnia and Croatia, certainly Croatia, it'll be much more difficult.
Let's take the question to Sonja. Do you think that really states need to decide what they want? Do they want reconciliation, or do they want justice? And perhaps the point which Geoffrey made is, you won't get reconciliation by going to court. You'll get punishment and hopefully justice. But perhaps if you want reconciliation, you need a Truth and Reconciliation Commission, which starts from the starting point of saying, we're not going to give punishments to anyone. We just want people to come forward and say that they did wrong things.
Well, these are two parallel things which are equally important. Justice, unfortunately, is never done for the victims that have suffered or who have been killed. Apart from that, I think the truth about the whole process is equally important for the victims as well, but also for younger generations that come who hardly have a clue what has happened, because they grow up on the models which are provided in each of these countries, mostly very limited in the scope, in the explanations, and so on. So well, reconciliation is a really long process of learning and bringing up.
It is a long process, and time, unfortunately, is running out for this show. Let's thank our guests here, Sonja Biserko in Belgrade, Geoffery Nice in London, and Marko Milanovic in Nottingham. And do let us know your thoughts. You can join in this discussion on Facebook and Twitter. I'm Sami Zeidan. Thanks for watching. Goodbye for now.